morning, good afternoon, good evening. I hope you're all doing well this very windy Thursday. I'm sorry I'm a couple of minutes late. I wasn't asleep. I was rescuing my washing. Pegged my washing out this morning and loads of it had blown off the line, so I had to go and repeg it all. All right, so the defence have rested their case, and Hank Brennan is not going to call any witnesses in rebuttal. That was astonishing. That was truly astonishing. After another crazy day in the Karen Reid retrial. Crazy day. Hank Brennan is losing his marbles. But I called it. If you were here yesterday in the live stream, I said, if I was Hank Brennan, I would not be calling Judson Welcher back to the stand. I would not call him. It's too embarrassing. It's just too embarrassing. I wouldn't call him. So, Hank Brennan, you know, great minds think alike and all that. Not that I'm likening myself to Hank Brennan. Who would want to do that? Anyhow, I'm full of allergies, so I'm sniffing. I've had so many antihistamines. I just simply can't take any more. Or else I'd be overdosing. So I'm stuffed up. I've not got a cold. If it sounds like I've got a cold, I haven't got a cold. It's allergies. I've got hay fever. It's terrible. It's really bad. It's really bad. At least my eyes are not streaming. It's just my nose. He is nuts. Absolutely insane. Insane. They haven't officially arrested yet. I think they did. They've not officially arrested in front of the jury. They have to rest in front of the jury. But look, today, for those who are completely confused, I was like, what is going on? What is happening here? What is happening? You know, if you turned it off after she dismissed the jury, you know, and said, I'll see you tomorrow, if you turned it off, you missed the best part. It was just absolutely nuts. Nuts. I've played it about, I don't know, 4 or 5 times. I've listened to various law tubers, and I still can't believe what really happened, that Hank Brennan is not calling any witnesses. Anyhow, we're going to go through the day. I've got a bunch of timestamps, and the defence's final witness was Dr. Andrew Rentschler from ARCA, and he asked a very, very important question. Very important question. How long does it take to eat a ham sandwich? Yes. Yes. How long does it take to eat a ham sandwich? He didn't say Hoz, he said how, but, you know, it would have been great. It would have been fantastic if he'd said Hoz long. That would have been so funny. But, I think he's lost the jury. I absolutely think he's lost the jury. Like, I've no idea what the jury must think about Hank Brennan. He is mentally unstable. He's so petty and spiteful and nasty. I don't know how he has any respect in the law community. I mean, look, he's not used to being a prosecutor. And if that's how he is as a defense lawyer, maybe it's successful. It must be successful in some ways because the guy is well known, apparently. But I just can't imagine how the jury must feel about him. And he knows it. He knows it. Now, does that mean that they're going to come back with an acquittal? Does it mean that they are going to find Karen Reid not guilty of all charges? if there's any justice left in the world, they absolutely should. They absolutely should, because there is no way that Hank Brennan has proved the Commonwealth's case. I mean, look, what has he actually proved beyond a reasonable doubt? The main thing he's got to prove is that a collision occurred. And he has not proven that. He has not proven that. Even the Commonwealth witnesses, like the most important Commonwealth witnesses, such as the medical examiner, Dr. Scotty Bello, she's not going to say that this was a homicide caused by a motor vehicle collision. The brain surgeon, Dr. Isaac Wolfe, said that he's seen injuries to John O'Keefe's brain and his skull by people falling over drunk. The most important, the most learned of the Commonwealth witnesses say that there's no collision. Well, they didn't say that, but it supports the defence case that there's no proof that there was a collision. And I think the defence have basically knocked the case out of the park. They really have this week. They've knocked the case out of the park. The last three witnesses, Dr. Daniel Wolfe, Lisbeth Lapasata, and Andrew Rentschler. If there's any justice left in this world, those three witnesses alone should have provided the jury with the reasonable doubt that is required under law to find Karen Reid not guilty of all charges. If Karen Reid is convicted, I've basically lost the little faith that I have, that I have left in the criminal justice system. And within that, I say that about my own country as well, because the United States, I know it varies by state, but overall, the justice system over there is very, very close to the justice system over here. That's why I was so upset about Richard Allen from the Delphi case. That there's no way that they proved the case beyond a reasonable doubt in the Delphi case. But yet Rick Allen is now in prison for the next 130 years. I lost my faith there, right there. But this surely is clear-cut now to the jury. Surely it must be clear-cut now to the jury that they cannot find Karen Reid guilty of any of the charges beyond a reasonable doubt. And if they do, I don't know. I think I'm just going to become some kind of maverick vigilante who takes justice into my own hands. I don't know. I will be absolutely gutted. Not just for Karen Reid, but for the system of justice and basically the use of jury trials. I can't think of a better way to do it. I mean, you know, some people say that there should be professional juries who know the law, but that's not how the law works. There have to be major changes to the criminal justice system if they wanted to take away the essence of jury trials. Like in this country, the jury trial system comes from the Magna Carta, the Great Charter that King John, who's actually one of my ancestors, I'll have you know, but King John in, 1215 AD, signed the Magna Carta that gave people in England the right to be tried. So the rights to not being unlawfully imprisoned and the right to be tried by a jury of your peers started in 1215 AD with the Magna Carta. So the system that we've got here in the UK, and that then was transported over to the United States, all comes from the Magna Carta. And to change that, to say that, okay, we're going to change the system and people are no longer being tried by a jury of their peers, is a bigger change, is a bigger deal than anybody really realizes. However, we're not here to talk about history. I do have a history degree as well as a psychology degree. I have 2 psychology degrees. I have a history degree. So, anyhow, it's not often that I get to talk about history. But there we are. There we are. All right. Okay. Hello, everyone, anyway. I haven't said hello to anybody. We'll very quickly see who's in the house. And then we're going to go through the day. I've got a load of timestamps. The court is only starting at 10 today, which is 3 p.m. my time. So we do have a little bit more time today. As long as I don't start sneezing and sniffing and doing all the things, we can stay for a while. Hello, Kimberly, Teresa. We've got Professor of Mathematics and Science. Honk if you like. Okay. Starting to feel a little sorry for Hank. Then I went, wait, that's the trap. Yeah, God, don't feel sorry for him. I feel pity for anybody who knows him in his life. I mean, is he like this all the time? Seriously? Is he like this all the time? I bet he has no friends if he is. Angie, baby, hello. Hello, Thunderhorse. We've got Windy Weather, 2 Arctic Wolves, Rescue Randy's Road Rash. Electric Waycott Truther Network. Interesting name. Sarah, Patrice, Dawn, Joanne. Don't think I'm going to get to the end today. Queen of Ravens, The Quiet Observer, Babe, Harry Potter. All right, I'm going to stop there. I'm driving everybody. I know, Delphi PTSD. That's exactly what it is. It's exactly what it is. Well, you're not going to see that because there's no more testimony. So if you were a juror, you would have to make your mind up now based on the testimony that you have been shown and you've heard. So if you can't decide based on the evidence that you've heard, if you are still on the fence, then you must render a not guilty verdict. Because if you're on the fence after all the evidence has been shown, it proves that the Commonwealth have not proven their case beyond a reasonable doubt, and you must render a not guilty verdict. So any fence sitters, anybody who's on the fence, you must find Karen Reid not guilty. That's the law. Going to do a poll. Right. So we'll look at the findings at the end. So I'm going to ask you not what you think the jury are going to do. I'm going to ask you what you would do. If you were a juror, would you find Karen Reid guilty or not guilty? Now, I know that there's 3 separate charges because there's the 2nd degree murder, manslaughter, and then the 3rd one, I think it's something like leaving the scene of an accident, knowing that you look. I can't remember what the third one. The third one is it's basically hit and run. All right, so I can't remember how it's worded in Massachusetts. So all charges, basically acquitted, all charges. All right. So if you were a juror, would you find Karen guilty so guilty of at least one charge, or not guilty of all charges? And I'm not giving you an out because all the evidence has been heard. So you have now got to make up your mind based on the evidence that you heard. Okay? So if you're on the fence, then you must acquit. All right, starting the poll. Okay, we'll have a look at that at the end. Okay, without further ado, we are starting at 27 minutes in, because the stream on Court TV started way before Bev got there. And Dr. Rentschler comes back to the stand. So Alan Jackson went through his experience and education and all of that the day before. So he's coming straight in, talking about the evidence now.
All right, Mr. Jackson, whenever you're ready. Are you ready, Doctor?
I am, yes, Your Honor.
Okay.
Thank you, Your Honor. Dr. Rentschler, good morning.
Good morning.
Yesterday, when we last left off, we were discussing materials that you had been provided to review, and you described much of that material in furtherance of your answer that you were asked to review certain data and undertake certain testing as it relates to testing that was done by Aperture, correct?
That's correct, yes.
Did you prepare a PowerPoint presentation to illustrate the analysis and methodology in your review and testing of this case?
I did, yes, sir.
Did you bring that with you today?
I did indeed.
Your Honor, I have a flash drive I'd like to have marked as next in order.
Okay. Is there an objection?
Not for identification.
Okay, so it's marked for identification.
KK for ID.
Let me know whenever. Pardon me. Let me know whenever you're ready, Dr. Rentschler.
Sure, do you want me to bring up the PowerPoint?
If you could bring up the first slide, let's start with
Sure.
that.
Let's see here. There we go.
Is this representative of the PowerPoint that you presented, or sorry, that you prepared for presentation for the jurors?
It is, yes, sir.
Okay. Are there several blank slides, just sort of placeholder slides as we walk through your analysis that the jurors will see?
There are, yes.
Okay.
The reason why there's a bunch of blank slides is because Hank Brennan got his own way, and a load of what Dr. Rentschler had prepared, the jury weren't allowed to see.
Let's talk about first of all, what was the purpose of your investigation? What did you seek to undertake?
So the purpose of my investigation in this matter was to evaluate the evidence, and particularly as it pertains to the alleged theory of what occurred in this case.
All right, so I'm going to strike.
So the very first thing that came out of Rentschler's mouth, Hank objected to it. And Bev struck it from the record.
Strike that answer. Ask the question again.
Sure. Did you seek
So that answer was not good enough for Bev.
to undertake an analysis of Aperture's testing or part of their testing?
I did, yes, sir.
All right. With regard to that testing, what was the reason that you undertook to analyze Aperture's testing.
Objection. Sustained.
Sustained.
Ultimately, were you in receipt of a PowerPoint presentation and a report from Dr. Judson Welcher?
I was, yes, sir.
Okay. Did you have an opportunity to review that PowerPoint presentation in whole?
I did, yes.
Were you able to look at his report and read his report and review his report?
I was, yes, sir.
Did you undertake an analysis based on his reporting and his PowerPoint presentation? Yes.
So I'm going to see you both at sidebar for just a minute, please.
My God. My God. There were so many sidebars. So many sidebars. Yeah, he got told off by Bev for saying happy birthday to his kid. The reason why he was bringing up his kids was because he was going to use it as an example, presumably some example that the jury would easily understand, given that probably the jurors have families or they belong to a family, but he wasn't allowed to, so we'll never know what that example entailed. And I do think it's a little bit appropriate for him to say happy birthday to his kid during a murder trial. But hey, if that's the worst that this guy has done, it's a very, very small price to pay for the amount of testimony that was really good and the way that he handled the cross-examination. I think he got a little bit more rattled than maybe I would have liked. He didn't come across as rude in any way, but you could tell he was getting a little bit rattled. But Hank was just so obnoxious, really obnoxious and petty, spiteful. I mean, for a good chunk of Rentschler's cross-examination, the jury must have been thinking, what on earth are they talking about? I mean, the jury are not even meant to know about the first trial. I mean, they obviously do. But Bev allowed it all. And, Alan Jackson got up and was like, admonish him. But she didn't. And the amount of objections and sustaining and sidebars that happened during the direct, and then how much she let Hank get away with during the cross-examination is astonishing. Absolutely astonishing. Astonishing. I cannot ever consider this woman objective. She's maybe not quite as bad as Judge Gull, because at least she allows us to watch the trial, but I don't know. Anyway, there's a sidebar. But eventually, they got round to discussing what Dr. Rentschler was actually here for. And once they got going, it was really good. So I'm going to fast forward here to about the
contact between Mr. O'Keefe's arm and the vehicle.
Could you describe for the jurors what hypothesis you used based on your review of the information you got from Aperture?
Sure. So the hypothesis that I looked at, Aperture, their testing and report indicates that Mr. O'Keefe had his arm out at a 90-degree angle.
Sustained.
What do you see? By the way, where are these from?
But he did. I don't understand what all these objections are. Look, I'm not a lawyer. And because Bev doesn't allow them to say objection relevance or objection leading or objection whatever, as a non-lawyer, it's difficult to know why she's sustaining these objections. And I'm sure that the jury will feel the same because presumably they're not lawyers either. I'm watching this as a potential juror. I mean, I'm not. I'm not a juror. I couldn't be a juror on this case because as soon as I saw John O'Keefe's arm, which would have been at some point in 2023, I think I started following this case. So it was quite a ways in before I really became aware of it. Like I knew the name Karen Reid, I knew the name John O'Keefe, but I really didn't start following it. I think it was a live stream by Deets on the Streets and Chasing, who used to be Chasing Truth, and potentially I think there was someone else. And I really sat up and started listening during that live stream. And it was then that I started to dig a little bit into the case. But as soon as I saw John O'Keefe's arm, I said, that's a dog bite. Those are dog bites. And everything else just fell into place. The dog bites. So therefore, any injury that John O'Keefe supposedly sustained by a motor vehicle collision just does not, absolutely, 100% does not make sense. It doesn't matter about anything else in the case. It does not matter about anything else. There was no collision. There's no evidence. Let's put it this way. There's no evidence of a collision at all on John O'Keefe's body. So I wholly endorse Dr. Elizabeth Lapasada as being the best witness of the two trials combined. She was so good. And I say that because she said exactly what I've been thinking for the last 2 years. There was no collision. It doesn't matter about anything else. There was no evidence of a collision on John O'Keefe's body. And if you cannot prove beyond a reasonable doubt that there was a motor vehicle collision based on John O'Keefe's body, that's your reasonable doubt. And the Commonwealth absolutely cannot prove their case beyond a reasonable doubt. Now, the timeline doesn't make sense. We've talked at length. I'm a timelines person. We talked at length on this channel about timelines in this case based on Ian Whiffin's testimony. And Ian Whiffin's testimony, again, another Commonwealth witness, proves beyond a reasonable doubt, in my opinion, that there is so much reasonable doubt. It proves it. Ian Whiffin's data dump from John O'Keefe's iPhone and Karen Reid's Lexus, the timeline there that Ian Whiffin set out, which Burgess and Welcher kind of base their work on, that in itself proves that the Commonwealth don't have a solid case. But even as a timelines person, even that isn't as important to me in my decision-making process. It isn't as important to me as John O'Keefe's body. The body tells the story. And in this case, the body says there's absolutely no evidence of a collision. And therefore, it has to be a not guilty on all charges.
These two slides.
These two slides are from the PowerPoint presentation that Aperture provided.
All right, so you didn't create these?
I did not, no, sir.
Describe the angle of the arm in the left photograph with the drinking glass in the hand.
So the angle of that arm is approximately 90 degrees. The other photographs in the PowerPoint demonstrate that for someone the same height as Mr. O'Keefe, the arm would be about 90 degrees with an individual standing erect. That's what was demonstrated in their PowerPoint.
Do you note anything in their PowerPoint, the Aperture PowerPoint, related to the clothing worn in that left photograph?
Yes, they have the surrogates wearing a hoodie or a sweatshirt, which is the exact same type. And
so it seems that it's acceptable to say surrogate. So instead of Dr. Welcher, we all know that's Dr. Welcher. We all watched his testimony. We know that's Dr. Welcher. But it seems that Dr. Rentschler can't say Dr. Welcher, so he's using surrogate.
brand that Mr. O'Keefe was found wearing at the time of the incident.
Did that play a part in your overall analysis, the fact that the individual, the surrogate, as you use the name, was adorned with the same type of sweatshirt that was found on Mr. O'Keefe?
It did, yes. I mean, that's one of the details that we have to look at. Details matter. So we look at the clothing that was worn and the evidence found with respect to that actual sweatshirt.
I'd like to stay with that for a second. Why is that important? Why would the clothing matter?
Well, because that tells us, that gives us evidence of what
The O'Keefe family are bringing a civil suit against Karen for unlawful death. But the civil suit is on hold until the criminal charges are completed.
may or may not have occurred. Mr. O'Keefe was wearing the sweatshirt when the time of this alleged incident occurred. So if there is contact between his sweatshirt and that rear vehicle, the taillight from the Lexus, there would likely be evidence of that. And we have to look at that sweatshirt to see the condition of that sweatshirt, if there's evidence on that sweatshirt, and be able to pair that or match that up to what happened on the vehicle.
And John O'Keefe's hoodie was a big bone of contention. And Hank Brennan, the other day, if you remember, had to back down and admit that he made a quote-unquote mistake, which Judge Bev, in my opinion, did not rectify to a satisfactory standard. But we've talked about that previously. But in short, if you've missed it all, when Dr. Daniel Wolfe, the other guy from Arcot, was on the stand, Hank Brennan showed him John O'Keefe's hoodie and said that the holes on the back of John O'Keefe's hoodie were caused by John O'Keefe falling after Karen Reid's Lexus hit him and knocked him over. And Dr. Wolfe said they're not road rash, they're not holes that you'd see in a road rash situation. And indeed, Dr. Wolfe was absolutely right, because they weren't. Those holes in the back of John O'Keefe's hoodie were the criminalist cutting it up for samples. So he had to admit he made a mistake. But what Bev said to the jury, I don't think is satisfactory, honestly. Now, I don't know whether today they're going to bring it back up, because today the jury are not coming in today. The jury are coming in tomorrow to listen to the closing arguments, and then they'll get the case after that. Today's the charging conference where they go through, the lawyers and the judge will go through the jury instructions, and I think that's going to take a while based on what happened in trial 1. And then there's a bunch of motions that they've got to deal with as well. So that's what's happening today. And they're only starting at 10. That's why I've got plenty of time here. I don't have to just, do an hour. I could do as much as I want, really, until 3 p.m. It's currently 12:19 for me. I'm not going to make this too long, but given it's the last day of testimony, and I feel it deserves it, because it gives us an ability to do a little bit of a recap as well, of what's gone on through the trial. All right, so clothing is important. It absolutely is. And what we see on John O'Keefe's hoodie, like on John O'Keefe's body, absolutely no evidence that John O'Keefe was knocked over, because the only holes in the hoodie that weren't caused by the criminalist were, I think there was 9, Dr. Rachel said, and I'm going to play the clip in a minute, but puncture, little holes that look exactly like the holes you get in your clothes when a dog claws, and you get a circular hole with a little kind of rip, or dog teeth. So I've had clothes ruined by dogs. I know exactly what those holes look like. Exactly what those holes look like. I've also had road rash and had clothes damaged by falling. Not by being hit by a car. Actually, I was hit by a car once, but it wasn't my body, it was my bike. Actually, twice. I've been knocked off my bike, my bicycle, twice by cars. So even though I personally wasn't hit, like my body wasn't hit, my bike was hit, and I fell. So I remember once, this car was right up my arse. It was like, honest to God, it was right behind me as I was cycling along, and I thought, I'm going to end this or mend this. And I slammed my brake on. And the car hit me and sent me flying over the handlebars. And I landed on the road in front of the car. The car had to slam on. And I was hurt. Didn't show the driver that I was hurt. The driver got out. And I stood up and I started to lay into him. I was furious, but my legs were pouring with blood. Like I had grazes all down my legs because I'd kind of like gone over and somehow landed like on my knees, kind of. So it had grazed like all down my legs, and I had leggings on and they were all ripped. And like it was very different pattern than I've ever seen before. Like just that it was like it was scraped. Like scraped, and I laid into him, and he was like going, "You were cycling too slow. You were cycling." Honestly, the nonsense that he said. It's like you could have passed me. I was like right up, like because it wasn't even like a single track road, like it was 2 lanes. But I was right up near the side. Like I couldn't have gone any further in the side. But I was cycling reasonably slowly, not mega slow, but I was reasonably slow because I had a bunch of dogs with me that were running down the side. So I think I was training my collie at the time to run by my bike, and then there was a bunch of neighborhood dogs that used to come out with us. So there was a bunch of dogs running down the side, and he should have just passed me. It wasn't a busy road. He should have just passed me. So I was fuming, absolutely fuming. I should have reported him, but I was only like, I don't know, maybe 16 at the time. Anyhow, I digress. I'm going to move us on about 10 minutes here to 52. Let's go there. So this is about John O'Keefe's arm and the medical examiner's report.
When you look at the extremities, everywhere where it talks about the extremities is superficial abrasions. So the first step in a biomechanical analysis, you review the medical records, determine exactly what the injuries are. And you can see there's a picture of the actual abrasions. Those are the documented injuries or abrasions to Mr. O'Keefe's right arm.
Are these acceptable sources? Well, let me ask you this. What are the sources that are reflected on this slide that you referred to or you relied on in coming to your opinions and conclusions regarding Mr. O'Keefe's injuries to his right arm?
Again, on the left side is from the autopsy report from the medical examiner, and then the right side is actually from the Good Samaritan hospital where Mr. O'Keefe was taken.
Are autopsy records, hospital records, medical records acceptable sources for a biomechanist to rely on in determining or coming to opinions and conclusions?
They are the sources you go to determine what the injuries are, yes.
Did you see, you reviewed the entirety of the medical records as well as the entirety of the medical examiner's file, is that right?
I did, yes, sir.
Did you see reference to any fractures that were noted on Mr. O'Keefe's right arm, either his arm, his forearm, or his hand?
No, there were no diagnosed or references to fractures on any part of his right arm or hand.
I'm going to ask Mr. Wolk to display a couple of exhibits, the x-rays.
Okay.
So he's going to take over the TV screen.
Sure.
If that's okay, Your Honor?
Yes.
Yeah, that's it, Robin. That's exactly what happens with road rash. You get like debris, like little stones off the road. Like I had, like my legs were bleeding, but in the wounds, there was a load of like little stones, which is really painful to like get them out. Like some of them were quite deep as well. And it was obvious that I'd fallen on a road. But there's nothing. There's nothing on John O'Keefe's body that would show that he's got road rash.
This is an exhibit that was marked yesterday. I want to say 226. I may be wrong, Your Honor. I'll get the right nomenclature in just a second. This is one of the exhibits, one of 3 exhibits that was introduced yesterday. Do you recognize what's depicted on this?
That's the X-ray of Mr. O'Keefe's right hand taken January 31st, I believe.
Did you review this in furtherance of your analysis?
I did, yes, sir.
Was it part of the medical record? Medical records or these records?
It was a series of the X-rays, yes, was attached. It was part of the medical records that were provided to me and that I reviewed in this matter.
Thank you. Just for the record, so I can clarify, this is Exhibit 229A, as in Apple. Do you see, have you looked at X-rays before?
I have, yes.
Have you interpreted X-rays in furtherance of your analyses in years past?
I have during my biomechanical analysis, yes.
Are you trained to look at X-rays and determine whether there are fractures, hairline fractures, broken bones, things of that nature?
I've been doing this for 20 years. In graduate school, I worked with surgeons and doctors to look at X-rays.
Is that part of the normal methodology that biomechanists undertake in furtherance of injury analysis?
It is part of what we normally do, yes, sir.
Would it be an important part of a biomechanist's ultimate analysis and conclusions as it relates to an injury analysis?
It would be, and especially in this case, if we're talking about impact to the arm and the hand, very important to determine, as I said, not only what the actual injuries are, but what injuries did not occur.
Exactly. What injuries did not occur. Like in a motor vehicle collision, if you're claiming that John O'Keefe was hit and spun around and flung 10 feet onto the lawn, then his body should tell that story. And there is absolutely zero evidence on John's body or his clothes that he was the victim of a motor vehicle collision. Therefore, that is an instant not guilty of all charges. Now, the X-rays. So Dr. Laposada had a look at the X-rays. She couldn't see any fractures or any evidence whatsoever on John O'Keefe's right arm, his hand, his shoulder. Like, the X-rays were shown to her. The X-rays have been shown to him. Now, he's not a medical doctor. He's an engineer. His PhD is in engineering. But because he's a biomechanist, then he does have the knowledge of how to interpret an X-ray and what to look for and so on and so forth. So the X-rays themselves, however, were a big revelation because Dr. Welcher from Aperture said that there was no X-rays. He hadn't seen any X-rays in this case. So he said, how do we know that John O'Keefe didn't have fractures? Because there was no X-rays done, which is blatantly untrue. I don't understand how this isn't a case of prosecutorial misconduct. I don't understand how Hank Brennan is not in serious trouble for the way that he's misled the jury twice in this case. First with the hoodie to Dr. Wolf, and second through Dr. Welcher's testimony, because those X-rays were in discovery. Those X-rays accompanied the autopsy report. So how on earth, if Dr. Welcher really had reviewed the autopsy report, how on earth did he miss a bunch of X-rays? You have to ask the question, did Dr. Welcher truly believe that there was no X-rays because he wasn't given them? That Hank Brennan purposefully misled Dr. Welcher, which is a possibility, given his track record, or has Dr. Welcher chosen to ignore them? We don't know the answer to that. But there absolutely was a bunch of X-rays, and it's proof beyond any reasonable doubt that John O'Keefe had no fractures anywhere on his body other than his head, his skull fracture that killed him, and 2 broken ribs, which were a result of resuscitation efforts. So there's no way Hank Brennan could have called Welcher back in rebuttal. Based on the X-rays alone, Dr. Welcher would have been destroyed on the stand. under cross-examination? You think the feds had them? Okay. So the feds kept them. So no one knew about them because the feds had them. All right. I don't know whether that's true or not. Right. We're going to skip forward about 5 minutes here. And we're going to go to John O'Keefe's clothes. So these little triangles here are what the criminalists put on. And those were the site of, down his right arm, those were the site of where the puncture holes were that look exactly like you get when a dog either bites your clothes or scratches your clothes. Like Tilly with her big talons sticks her talons through my clothes. I've got holes in my clothes because of Tilly. You know, big talons. So we got 1, 2, 3, 4, 5, 6, 7, 8 that we can see there. I think there was 9, and then there's a couple on here. I'm not sure what they're to indicate, but let's listen to a couple of minutes here.
In your injury causation analysis.
So this shows the hoodie, and it was inspected by the police department, and it was noted, as you can see on the right sleeve by the triangles, there were 9 different punctures or holes noted in the sleeve of the sweatshirt.
Can we go to the next slide?
So there must be one that we can't see on here, because 1, 2, 3, 4, 5, 6, 7, 8. There must be one that we can't see.
Slide, please. What are we looking at in these series of photos?
So let's move to sidebar for a minute, and Mr. Jackson, bring your PowerPoint first.
So they got to do a sidebar, and they got to discuss this with the PowerPoint, and they were a while. So we're at 1 hour exactly. So going forward, 13 minutes. 13-minute sidebar. Actually, 40 minutes by the time they've got back to sit down. There were so many sidebars in this day. Unbelievable. Unbelievable. I'd love to know what they discuss at these sidebars. I'd love to know.
Tori, can you get me a couple of these? Okay.
And Dr. Winchler, my eyes aren't good enough to see the upper right-hand corner. What slide number is this?
Number 12.
Number 12, thank you. Did you look at these photographs and consider these photographs in furtherance of your ultimate conclusion?
I did, yes, sir.
Can we move to slide 13, please?
So whatever was said at the sidebar, Jackson must have won because they go back to talk about the holes.
Did you also look at and consider these photographs in coming to your ultimate conclusion?
I did, yes.
Can we move to slide 14, please? Did you look at and consider these photographs in coming to your conclusions and opinions regarding this case?
Yes, sir.
Can you move from slide 14 over to slide 18, please?
So if you can see that they've just been punctured, and then a little bit, it's like where a dog, the claw goes through, or the tooth, I guess, goes through, and then the dog pulls away. So you get a little bit of a rip as the dog pulls away. That's what happens. And that's exactly what this is. Exactly what this is. Without a doubt, without a doubt. There's no doubt in my mind whatsoever. I've never been more sure of anything in my life. All right, we're going to skip us on about 10 minutes to... Oh, we've got another sidebar. Oh, no, I don't think it was a sidebar. All right, so this is great. This is fantastic. This is Dr. Rentschler looking at the directionality of these wounds. So yet another way to look at this arm, look at the position of them, and consider how these wounds could have occurred by the arm coming into contact with a tail light. So this is great. This was a great graphical demonstration of how this couldn't be. It just doesn't make sense to say these wounds were caused by coming into contact with Karen Reed's tail light.
With the arm at approximately 90 degrees.
What was the import of this this undertaking?
Well, if you look at the paint test and the way the arm's at 90 degrees and having the car come and essentially contact and push the arm out of the way, that's going to give you or tell you the directionality or the direction of the abrasions. Because if you have your arm at a right angle, and the vehicle comes and pushes and slides against it on that forearm, you would expect those abrasions to be horizontal, to be in line with that forearm.
Are they?
They're not. You can see some of them are vertical, some of them are angled, some of them it's hard to tell what the directionality is. But if your arm, again, is being struck and pushed this way, as it's pushed and as the car goes by, if this would occur in this manner, you would expect those abrasions to be horizontal in the direction that the vehicle is actually traveling.
When you say horizontal, do you mean horizontal from the elbow to the wrist?
Correct, or parallel, yes, with the forearm.
Can we go to slide 26, please? This is yet again the same video that we saw earlier.
That is correct. This is the paint test video, yes.
And what has to happen in order for the paint in this test to reach the upper forearm?
Well, in this case, to reach the upper forearm, there has to be contact between the forearm.
To reach the upper forearm, he has to basically bend into it and then roll himself around. It's like paint by freaking finger painting. Dear God. It's like play school. So we do play school.
Arm and the taillight cover.
Can we go to the next slide, please?
This
What
is
this slide
great.
showing?
Again, this shows, you can see on the right, I added arrows to kind of show the directionality of the different abrasions. And on the forearm, they simply do not line up with the type of kinematics or the type of motion shown in the paint test. Again, of the arm getting pushed out of the way and the car traveling past. If there were going to be abrasions from the fractured glass as it moves along, again, it would be lengthwise parallel to the forearm.
Exactly. And they're absolutely in the right direction and in the right combination. If you look at the arm as it is here, for a dog to come up here, so the dog's jaw comes along here and snaps at him. So you get some canine teeth wounds. You've got some little incisor bites down here, the little bit of bruising starting to develop. And then you've got these scratches here and here and here. I think those are scratches. I'm not sure about those two. I don't know whether they are teeth marks, but I think based on the position, I think they are scratches. I think that would be the dog's left front paw there, and that would be the dog's right front paw, and then you've got the dog's jaw here. And because it's on the elbow, the dog can't connect, so they're just little nips. I do believe there's possibly two different nips. So she's gone, not connected, like, you know, she's not actually been able to bite him properly, and she's tried again. But because it's bony and he'll been moving his elbow, she's not really connected at all. They're very, very superficial. So you've got the scratches here, left paw, right paw, and then the bite there. Absolutely in the right position of where you'd expect to see if a dog came up and you were like defending yourself, like holding your arm to defend your body. Exactly the right position that you'd see, that you'd expect to see the wounds. That's really good graphic. That I really enjoyed that graphic. There was another really good graphic. I don't think I've got it on the timestamps. That this was really good as well. This was really good. Like they've got this screenshot of one of Dr. Wolf's tests, and this is Rescue Randy, and it shows how, as you know, the tail light's broken there, so you've got a few pieces of the tail light which will fall. Pretty much, they'll go like the car's moving this way, so they'll go a little bit forward because they've got a little bit forward momentum. But the arm, as soon as it's like struck the tail light, the arm's flung off. So there's no damage to the hoodie that Rescue Randy's wearing. There's no damage to the hoodie. There's no holes. There's nothing. And if there's no damage to the hoodie, then, well, it proves that there's no damage to the arm either. Very powerful graphical representation of how you would expect, if this was a side swipe, you would expect to see how the tail light pieces would come out and land. And I think there'd probably be some pieces inside as well, like just that initial force possibly would send some pieces in, and then the ones around the side, as the car's moving, they're going to be forced with some forward momentum. They're going to be forced forward maybe a few feet, so the debris field is just going to be circulated around here. That you're not going to get taillight pieces that are 10-20 feet away on the lawn. You're absolutely not. Seriously not. And no damage whatsoever to this hoodie, proving that there would be no damage to the skin that's directly under the hoodie. You can't have zero damage to the hoodie and then damage to the arm. You can't. It's impossible. The arm, the damage to the arm would correspond with the damage to the hoodie, obviously. Obviously. All right. Brilliant. I thought this was really good. Really clear. Really clear. And I thought Jackson, his once they got into it, once they stopped with all the terrible objections, once they really got into it, this was outstanding work by Alan Jackson. Very clear. Like the questions he asked, the attention to detail, and the way that Rentschler had prepared, these slides is outstanding. Outstanding work. All right. Because it was so outstanding, that's the reason why Hank had to object to a whole bunch of them. So we'll never know what Hank objected to, because it was loads of them that didn't get shown to the jury. So we're now going to go to Hank Brennan's cross-examination. Okay. We're going to 321. 321. And I'm only going to play a handful of these clips because, quite frankly, I can't listen to all this again. Quite frankly, I don't want to ever hear Hank Brennan's voice ever again. Quite frankly. So we're only going to play a few pieces here. So 321. We'll start at 320 just to give us a little bit of context. But this is pertaining to the first trial when Rentschler testified. Now, at the first trial, Arca's testimony was basically what they'd done for the federal investigation. Like, the defense didn't talk to them. The defense hadn't prepared with them. The defense, obviously, they had some conversations with them to actually get them there, but they hadn't prepared in line with what the defense would want them to have shown. So that's why the testimony last time was much shorter and much less detailed than it is now. Because now, in trial 2, they are working for the defense. They're paid by the defense, they're working for the defense, and it's based on, like, all these this new stuff has all come from counteracting Aperture. But in trial 1, which the jury are not meant to know anything about, in trial 1, they were employed by the feds. They were paid by the defense to testify, but their investigation was all done as part of the federal investigation. They just agreed to come to testify in this trial with the findings that had been done for the federal investigation. So it must have been really confusing for this jury to hear all this nonsense. And it went on for seemingly ages. It was just like, when is this going to end? When is he actually going to be asked any questions that pertain to the investigation? All right, so this is where we're at here.
No need to.
That's not the question. Details matter. Was there any attempt?
So the objection's sustained. I'm going to strike that, folks.
Questions,
Mr.
she finally, one of the only times she allowed Alan Jackson to win an objection.
Was there any attempt in your conversations to portray yourself as independent as far as your arrangements were concerned and coming out here?
No, I don't think so, because there was no need to, because it was independent.
When you had conversations with the defense, did they offer to give you transportation assistance getting here?
They provided a ride to and from the airport, yes.
Did you tell the defense that you prefer to take an Uber so that it would appear independent to a jury?
No, because I didn't take an Uber. I took their ride. If I wanted to appear independent, then I would have taken an Uber.
So we've got, in a murder trial, we've got the witness being questioned about whether he took an Uber. I mean, I can't believe how petty this is. This is Hank Brennan's personal gripe against this man. It has absolutely no use to this jury. It's absolute, and it gets. I couldn't believe what I was hearing. If you missed this testimony, oh my word, you have missed an absolute corker. You couldn't make this up. You truly could not make this up.
Conversation about that you were thinking about taking an Uber.
It didn't even cross my mind, sir.
And then after you testified, did you stay independent?
What do you mean independent?
Did you have any bias or anything?
Any bias?
Bias, yes.
What do you mean? Did I have any bias?
Well, after you testified, where did you go?
Well, I was waiting for my ride, and to get back to the airport, they had to take other people, and so they were having a lunch afterwards, and they said, come have a sandwich, and then your ride will take you to the airport. So I went, and I had a ham sandwich.
You had a ham sandwich.
Had a ham sandwich. Oh my God, he had a ham sandwich. No, that proves his bias. He went and had a ham sandwich. No, got to strike all this testimony. The jury have got to ignore all this testimony because at some point last year, after he testified with data that had been collected and investigated and analysed as part of an independent federal investigation, he is now free to talk to whoever he wants. He's free from his subpoena and all that. And while he waited for his ride to the airport, he went for a ham sandwich. Jesus. Look, I'm going to object. Objection. Ham sandwich. Objection. Because I'm a vegan. I don't want to think about ham sandwiches. I don't want to think about my friends being eaten. Right, so I object based on the filling of this sandwich. Jesus Christ. Man alive.
Did you testify at some point that after you had something to eat, you just stood in the corner?
I did. I sat at a table, ate, and then went over and literally stood in the corner waiting for my ride.
There is a picture, one of the guilters on Twitter yesterday, and I didn't save the picture. I just was kind of scrolling through. There's a picture of Andrew Renschler standing up at this meal, like this ham sandwich thing. He must have that you can't see the ham sandwich. He must have already eaten that. But he's standing up talking to Karen Reid's dad. No way. He's talking to Karen Reid's dad. And one of the guilters put this to prove, showing this evidence to prove the bias of this guy. Hamming it up with the defense. It's just ridiculous. Oh, dear.
When you sat at the table and eat, did you just eat your ham sandwich? Or did more go on?
I ate. People were talking. I really didn't talk much at all.
Did you listen?
Well, certainly, I'm sure I did, sir.
No, he didn't listen. He put his fingers in his ears.
I assume if something funny was said, I probably laughed.
Did you talk about your testimony?
Hank's tofu brain. Maybe Hank doesn't like ham sandwiches and he prefers tofu. Listen, I like tofu. I don't eat tofu very often. It's a kind of bland. But I tell you what, Tofu's nice, like the soft tofu is nice in a blender with blueberries. You can make blueberry ice cream. It's very nice, like frozen blueberries. You can either put frozen blueberries or you can put regular blueberries with some ice cubes. And you can make it. It's exactly like ice cream. It's so nice and so healthy. So all you need is 2 ingredients: frozen blueberries and soft tofu. Blend it so it's really smooth and it's delicious. It's called blueberry ice cream.
At this point, I don't even remember.
Let me alert you of something. When you were there at the luncheon, did you see a camera crew
I believe I did, yes, sir.
filming and documenting, right?
There were a lot of cameras, yes.
You know that you might have been on some of that footage?
That's fine. I could care less.
Was there mustard? Oof, I don't know. And if there was, what kind of mustard was it? Never eaten tofu. It's kind of bland. You have to like dress it up. Like you have to put stuff with it. You can't just eat tofu. It doesn't really taste very much. But it's, you know, if you're good at cooking, you can make it into all sorts of different things. So.
Yes.
Okay. So do you think maybe you were talking about the case and their answers and laughing it up a little bit?
I have no idea. Possibly.
You were involved in conversations with the defense attorneys, were you?
What do you mean conversation, sir? I had just gotten done testifying. I was having lunch. Whatever was spoken about at the table, I'm sure I heard.
He testified he's free from any subpoena that he had. He can talk to whoever he wants. If he wants to go for a meal with the defense, he can do. I don't understand. Like, what were the jury doing? Were the jury taking notes about this? About the fact that Dr. Rentschler ate a ham sandwich and listened to some conversation while he was waiting for his ride? It makes a fab cheesecake. That's true. I have had tofu in cheesecake. Yeah. That is nice.
You know what a conversation is when someone speaks to you and you answer.
Sure.
Did you have conversations with some of these folks?
Sir, I can't remember conversations I had last week, let alone a year ago. So I probably did, but I have no clue
Do you remember
what we would have talked about.
Do you remember accolades you might have been receiving because you had given certain answers to the then prosecutor on the case and laughing about the answers?
I have no idea. I can't remember last week what I had for lunch last Tuesday. How would I remember a conversation from over a year?
People have been saying, why did Alan Jackson not object to this? Why did he not object? Because this is just a ridiculous line of questioning. No, I agree. He shouldn't object because this makes Hank Brennan look absolutely ridiculous. This is great for the defense because it just makes Hank's questioning seem petty, spiteful, and completely irrelevant.
A year ago.
Do you remember when you were having conversations with some of these folks and you were laughing about when the prosecutor asked you about other evidence like DNA? You had a response, well, the physics doesn't change. You remember?
I don't specifically remember that, no, sir.
How long were you at the table eating your ham sandwich with the folks there enjoying the event? How long do you think that went on for?
I honestly don't know. 10 minutes? How long does it take you to eat a ham sandwich? 10 minutes?
He should have said, how long does it take to eat an ham sandwich? Honest to God, I would have died. I would have died if he said how's long. Oh dear. How long does it take to eat a ham sandwich? I think 10 minutes is like, unless it's a really big sandwich, like a really big, like Subway style sandwich. If it's just a regular bread, I don't think it takes 10 minutes. I think it might take like 5 minutes. I don't know. I'm going to have to make a sandwich and time myself. I mean, it's just insane. However, they did finally get to some relevant cross-examination. So we're going to jump forward a little bit to 3:48. Jump forward about 25 minutes. 3:48. All right. Can't remember what this timestamp's about, but it's about the case, thankfully.
With the same force, with different injuries. I don't even know if you can correlate that.
Looking at Exhibit 1.
Oh, yeah. This is where Hank Brennan blows up his own case. This is beautiful. Again, this is another beautiful moment for the defense He blows up his own case. Hilarious.
Have you done any study about the directionality of glass or broken plastic?
What do you mean by directionality?
About when something shatters, how it shatters. Does it shatter the same every time, or when plastic shatters, does it shatter differently?
I mean, it certainly depends on the impact.
Do you have any studies where plastic shatters exactly the same way on different impacts?
I doubt that it shatters exactly the same way.
It has a lot of different variables, doesn't it?
It could.
Depends on a number of different equations, doesn't it?
Well, it depends on the testing you do. If you want to see how it shatters, and if you're claiming that it shattered in a certain way to cause a certain injury, if you don't have any peer-reviewed evidence, if you don't have any research, then you have to do the testing, because you can't just say, well, it's possible it could shatter this way and cause that injury. That's not conclusive. You can't use that to come to an opinion about what happened.
Oh, that wasn't what I was asking you. I was asking you if you have seen in cases that when plastic breaks, it breaks differently.
Yeah. Well, sure. I mean, the testing we've done here, the taillights covers fractured differently, and we didn't get any contact. So I have personal experience just with this case alone.
We'll get to the contact. When you look at all the tests you did, the plastic broke differently in each and every case.
Asked and answered. Again, Alan Jackson's not objecting because Andrew Rentschler is doing great here. And Hank, once again, is just looking silly. But at least it's about the case. But however many times Hank Brennan asked the question, it's still the same answer. Because they did a bunch of different tests. So yes, in the experiments where the taillight did break, yeah, you're going to get a different number of cracks. You're going to get different number of pieces that actually fall on the road. You're going to get different styles of breakage because every one of the experiments they did was different. There was different speeds, different positions of the arm. Like they had one where it was one of them that was just the arm rather than it being on a dummy, just the arm, and it broke not just the corner piece, but the piece, like the straight piece. I don't know what they're called, but the arm was kind of a little bit more forward, I think, and it brought the taillight in a different way, brought a different part of the taillight. But yeah, of course, you're not going to get the taillight breaking in exactly the same way every single time. And in Arca's experiments, because it was different speeds and different positions, of course the taillight's going to break differently. And I'm sure that the logical members of the jury will read between the lines here and realise that Hank Brennan is being stupid. I mean, if this is a genuine concern of Hank Brennan, then it's just completely unfounded.
The experiment, didn't it?
Sure, it's broken like that, and I've never seen a case where you get these types of abrasions.
I didn't ask you that. Is that funny?
It's not funny.
Okay.
So I'm going to strike the comment. Next question. Next question, Mr. Brennan. No
Oh dear, is that funny? Yes, it is funny. Yes, it is funny. I don't think he could really believe what he was doing. He's like questioning his life choices at this point, but doing really well. And he wasn't laughing. He wasn't laughing. But it is funny. It is funny. I mean, how he kept a straight face through the ham sandwich thing, I've got no idea.
more comments.
No more
When
comments.
you did your experiments, the sizes of plastic that broke were different in each experiment, weren't they?
They were, yes.
The number of breaks in each experiment were different, weren't they?
They were, yes.
The angles of the break changed from piece to piece, experiment to experiment, didn't they?
I'm sure they did.
They did, because it was different speeds and slightly different angles of the arm. So, of course, especially when you get up to the higher speeds, you're going to get a different number of pieces breaking based on very small differences in the positioning of the arm. So that's to be expected. It would be bizarre if they'd broken all in the same way, in exactly the same, given that there was all different speeds and different positioning.
Did you watch the videos and watch the damage and take a look and count how many pieces broke in each experiment?
I didn't specifically count, no. We looked at contact to the sleeve and to the dummy itself.
You never counted the broken pieces in each experiment?
I did not. There was no need to.
Not a matter if there's a need, did you?
I did not, no, sir.
Okay. You had talked quite a bit about Dr. Welcher's test with the paint, so I want to ask you some questions about that. Were you ever under the impression that...
This is hilarious. This is the moment where Hank Brennan gives up. Like, or at least I'll rephrase. I'll ask it. I'll rephrase. This is the place where Hank Brennan should have given up, because he has disproved, he has shat all over Dr. Welcher's testimony. And if there is any justice in this world, at this moment, the jury should have written in synchronicity, all together, not guilty. Because there is no proof in the Commonwealth's case. The star witness, Dr. Welcher, Hank Brennan, has shat all over in this, what's coming up right now. There is no proof that the Commonwealth have not proved one iota using any method whatsoever that matters. Not some EMT or Jen McCabe saying, oh, Karen said I hit him, I hit him, I hit him. No, actual experts, medical experts, engineering experts, all of those that matter have not proven in any way, shape or form that John O'Keefe was hit by Karen Reed's Lexus. That's an automatic not guilty of all charges. If there is any justice left in this world.
Mr. Welcher, you can take that down, please. Were you ever under the impression that Dr. Welcher was trying to reenact the actual collision when he did that blue test?
I'm going to allow it.
Well, that was the only test he performed, and
I honestly, if I was Jackson, I wouldn't have objected there. So I'm glad Bev allowed it, and she allowed a lot. She allowed a lot of nonsense here in this cross-examination, but I'm glad she allowed this, because Hank is walking into a trap of his own making.
referenced that test for his opinion that the position and orientation of the lacerations are consistent with the taillight cover. So if that test was not intended to signify or demonstrate the position of the arm, he has no evidence to say the position and orientation of the arm in the lacerations, which are abrasions, are consistent with the taillight cover. That's the only test he did. So if it doesn't represent that, it's really meaningless in his analysis and conclusions.
Now that you've shared your opinions, can I get back to my question?
Sustained. So, Mr. Jackson, Mr. Brent, I'm going to see counsel at sidebar.
Oh. All right, we get a long sidebar. Oh. What do we get here? Oh, we get lunch break. So we get a sidebar, then we get lunch break. Okay, we're back. I hope there wasn't ham sandwiches involved. But listen, if Welcher, in his paint experiment, was not intending to reenact John O'Keefe's supposed collision, then what on earth was he doing? Like, he dressed up as John O'Keefe to the same t-shirt, the same make of jeans, the same make of hoodie, a cap, the same shoes. He literally dressed up as John O'Keefe, went to lengths to match up the clothing, even the colouring of the clothing he matched up. And then he says, well, I'm of comparable size. John O'Keefe was 6'1" and 216 pounds. And Dr. Welcher is 6 foot, and at the time he was about 200 pounds, so very similar in size and weight to John O'Keefe. And then the only experiment he did was with blue paint on the taillight and him rubbing his arm on it. And then doing one's kind of static where he just rubs his arm on the taillight, and then one at 2 miles an hour. And if anybody wants an actual reminder of it, well, here we go. Hold on. Here's an actual reminder of it.
Around the mulberry bush, the monkey chased the weasel. The monkey thought 'twas all in good fun. Pop goes the weasel. A penny for a spool of thread, a tuppence for a needle. That's the way the money goes. Pop goes the weasel. Monkey chased the weasel. The monkey thought 'twas all in good fun. Pop goes the weasel. A penny for a spool of thread, a tuppence for a needle. That's the way the money goes. Pop goes the
And I still have no words. Zero words. So you dress up as John O'Keefe. Like, not the literal clothes, not the actual clothes, they're in evidence, but the same style of clothes, the same make of jeans, the same make of shoes, the same make of hoodie, with the cap on. And then he even had a glass in his hand. And he even tried to get the same glass. He even tried to get the same glass that Karen Reid would have got from the waterfall, even though she actually didn't get the glass from the waterfall. She got it from McCarthy's. But anyway, he even tried to match up the same glass. Yeah, could literally do this. Do you think someone will pay me $400,000? Yeah, exactly. $400,000 the Commonwealth spent on Aperture's report, and that is the only experiment that he did. Oh, and he dropped a crash test dummy. Like, he held the crash test dummy up and then just dropped it. And it fell backwards and hit its head on the ground. That's it. That's it. So in Hank Brennan merely questioning Andrew Rentschler on, do you really think that Welcher was trying to replicate exactly how John O'Keefe was hit? Well, if he wasn't, what on earth was he doing? If he wasn't, was he just playing around with paints on a piece of... Like, they bought an entire Lexus. They literally bought a Lexus. That like the same make, model, and year of Karen Reid's, the same colour as Karen Reid's. So if this wasn't meant to be a replication, what on earth was it? What on earth was it? All right, they're back from lunch.
What is now open, maybe seated?
All right, while the jury is on their way in, I need to see counsel at sidebar.
Oh, God. Dear God, I'm a sidebar. All right, we're back. All right.
you wrote a report back in February 2024,
Yeah, that's correct, yes, sir.
and in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's
Back in 2004, I think he means 24.
arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not.
Yeah, get some blue paint on your arm, spin around, buy a house in cash, sign me up. Exactly. Why didn't you use Karen's? Because that's in evidence. I don't know why they didn't use Karen's. Because Trooper Paul used Karen's, didn't he? Trooper Paul used Karen's. I don't know, actually, why they didn't use Karen's.
Superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
And the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
Listen, no, they don't routinely do MRIs or autopsies. But listen, whether you use a CAT scan or an MRI wouldn't have mattered in any way, shape or form, because at 24 miles an hour, that arm, if it genuinely had hit a taillight at 24 miles an hour, you're not talking about ligament damage. If there's no bruising and there's no fractures, and there wasn't, no fractures, no bruising, there wouldn't be any ligament damage. Why? Because it didn't happen. It did not happen. All right, I'm going to move us up a few minutes to 5:19. Let's go there.
To look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently...
I'll just take it back another minute, because this is where they go back to talking about the position of the arm.
That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation and position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
So Retrial got it in yet again. That's the only experiment that Welcher did. And if it wasn't intended to be a reenactment, then what on earth was it for?
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was...
I mean, Hank just keeps going. He keeps going. He's shitting on his star witness multiple times. He's got verbal diarrhea. He just keeps going. Does he not realize how harmful this is for his own case?
is hit by a Lexus.
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that.
Inferred that that's how he believes that the arm was positioned?
I think we understand your perspective is that's the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying.
It just keeps going.
You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welch ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually,
If he wasn't trying to explain the body position, what on earth was he doing then?
he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area.
Exactly.
But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished
Well,
or
I'm
represented.
asking you. You've made assumptions, and then have given opinions to this jury based on your assumptions, haven't
He
you?
had chance. When they first brought it up before the lunch break, and Alan Jackson objected, and then they had a sidebar, then they went for lunch, then they had another sidebar. Hank Brennan had ample chance to realise that that line of questioning was going to blow up his star witness. But he obviously circled back to it and had absolutely no comprehension whatsoever about how bad this sounds for his star witness.
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I changed my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
He's trying not to laugh. He is trying not to laugh.
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything, that states Dr. Welcher was stating or claiming that he knew the body position?
Listen, you could object here to asked and answered, but no, it just keeps going.
John O'Keefe when he was struck.
I'm going to allow that.
Jackson does object. He actually does object. And I bet that's asked and answered. And she says, no, I'm going to allow it. She lets him keep going.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
Do you
You're
know
correct.
whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how
Well,
far.
we know it wasn't 2 miles an hour. So now Hank Brennan now starts to doubt his own witnesses who previously have said that Karen Reed was going at 24 miles an hour when the collision occurred. So not only now is he shitting on Welcher, he's also shitting on the other testimony from previous witnesses about how fast Karen would have been going when she hit John O'Keefe. Dear God.
If at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that actually occurred. That's the basis. Yeah.
So,
If you
Just keep saying you can't prove it occurred. You can't prove it occurred. There's no evidence that a collision occurred. Oh dear, Hank.
Don't have the
You can't-
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
So if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
Oh, and Hank just, oh, wow. That is beautiful, especially given that this is the last testimony that the jury hears. We all assumed that there was going to be a rebuttal case, but no, this is practically the last thing that the jury hears. How impactful is that for Karen's case? How impactful is that? All right, but it keeps going on and on and on. But in the interest of moving us on somewhat, we're going to move to 647. And we are now, so we get cross-examination carries on. We've got some redirect, and then he goes, and the jury are now dismissed. Let's listen to the jury being dismissed here. Oh, that's a sidebar. That's still a sidebar. I think my timestamp's wrong. 6:46. I'm on 6:46 nearly. All right, they're coming back here.
Jurors, we're going to release you for the day.
All right.
We will see you tomorrow morning. Those same cautions, please.
All right. So, see you tomorrow morning. So, Bev was expecting that there was going to be a rebuttal case. Everything was set for the rebuttal case. And then Hank Brennan drops a bombshell. So they stay behind. So the jury gets dismissed. They start having an argument about the PowerPoint. So there's a sidebar. They argue about the PowerPoint. And then, oh God, it's a long sidebar. All right, we're back. We're back. Okay, and this is the last timestamp I've got, and I'm still too far. All right. All right, we might as well start there.
Court's back in session, you may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
Exactly the substance of Dr. Welch's
Which was not objected to, right?
Yes.
But did he object to the PowerPoint coming in?
So they argue about the PowerPoint. All right, whether the PowerPoint can be put into evidence. Okay.
Okay, so I need you to tell me tomorrow which slides specifically answered that question for me, okay? Whether they're in evidence or not, and which ones are not, regarding the videos. Maybe. I'm going to take a look at it. There's an objection before me now, so I have to rule on the objection. So I will take a look at this, okay? So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welch's. I did not object to Dr. Waltz, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon.
You're objecting to this PowerPoint because you know how damaging it is. You don't want the jury to be reminded of just how damaging this testimony actually is.
Charges, only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from using it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have posed that objection before it was displayed for the jury.
Well,
Exactly. They already objected. They took out a bunch of slides based on that objection. Now he's objecting to the whole thing.
You're not seeing the entire PowerPoint. I think it's tactical. It's not strategic. It's tactical. They just don't like it because it's the case. If they didn't want to get certain things before the jury, which is exactly what admitting into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request, at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing before the jury. Given the fact that it's been displayed not in part, in whole, as it now assisted for the jury, assisted for the court, for quadruple K for identification, it should be admitted.
okay.
Just like Shannon Burgess, it's no different.
All right.
PowerPoint is an evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right.
Oh, joy. We're going to get this discussion. We're going to get this discussion. So a bunch of things we're going to discuss today.
Is that it for today? Will we see everybody just tomorrow morning?
not
What else
it.
do-
Mr. Leslie needs to, I didn't mean to interrupt.
We should get a year for first.
So Bev is still under the impression that there's going to be a rebuttal case. Still at this point, Bev still thinks there is a rebuttal case, that they're going to have some discussion tomorrow and then the rebuttal case is going to start. But no, watch.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
After the defendant's rests, we will not be putting any further witnesses on. No rebuttal case. Now, the defense has to formally rest in front of the jury because they've said they've rested, but I think the jury had been sent home at that point. But they have to formally rest in front of the jury, and then Hank Brennan can formally say that there's no rebuttal case, but it all has to go in front of the jury.
Okay. All right.
Your Honor, it's late in the day. We would like to review required findings not just the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
okay, great. So,
The technical thing is you need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they did mark for identification.
no, they were marked as evidence, right?
They're correct, Mark.
All right, so, okay, that's it. That's it. All right, well, I never thought one of the most contentious issues of this case was going to be how long it takes to eat a ham sandwich. But that's what we've come down to. And no, that picture there is not actual ham. That is a vegan replica of ham, which personally I do not like. But anyhow, just to point out that I've not got a picture of a dead pig on the screen, just to let my vegan friends know that. So today we have jury instructions, the charging conference. They're always boring. However, I think this one might be slightly interesting given what happened after trial 1. It might be slightly interesting, and there's a few things that they still need to clear up. And then tomorrow, the jury will be back in for closing arguments and jury instructions. Then the jury get the case. So the question is, how long do you think these guys are going to deliberate for? So I'm going to end this poll and I'm going to put up a new poll just for a couple of minutes here. So if you were a jury, would you find Karen Not guilty of all charges, 90%. Guilty of at least one charge, 9%. So where's the where's the other 1%? I don't know. I don't know where the other 1% is. So technically, that would be a hung jury. If you guys were the jury, technically that would hang, unless the 9% that believe Karen's guilty could be swayed by the arguments of the other 90%. Okay, one more poll, just for a couple of minutes. How long do you think the jury will deliberate for? Long do you think the jury will deliberate? Okay, I'm going to go... I can only do 4 options, so I'm going to do less than 3 hours. Now, 3 hours, Alec Murdoch's case, if anybody remembers Alec Murdoch, the jury came back there in just about 3 hours. So, less than a day. No, yeah, less than a day. And then 2 days, and then we're going to do hung. So it's a bit of a rubbish poll, but I can only do 4 options. But you can obviously put in the chat if what you think doesn't marry with any of these, then put it in the chat. So less than 3 hours, less than a day, 2 days, or hung. So do you think it's going to go on and on and on and on and on like last time? What was it? Was it about 5 days? Can't remember now. And the jury came back, and then they came back again, and they gave the Chewy instruction, and then they came back a 3rd time, and then she declared the mistrial. I want to say it was maybe about 25 hours. Am I remembering that rightly? I'm not, can't really remember. I've kind of blocked that period of time out of my mind. I mean, verdict watch. I do like a good verdict watch. But when it comes like to, you get into 2 days, 3 days, 4 days. I mean, the Delphi one, when we were waiting for Delphi, that was excruciating. I mean, really excruciating. And I was thinking they're going to hang, they're going to hang, they're going to hang, and then they didn't. They found him guilty. But in this case, I think if it goes longer than 2 days, I'm going to be really, really fretting. I'm going to be, please get this over with. I just can't deal. I don't know how Karen's feeling right now. I really don't. I mean, listen, worst case scenario, what if they get the case, let's say lunchtime tomorrow? You know, if they start at 9, I think by lunchtime they'll have done. What if they take 2 or 3 hours and they come back with a guilty verdict? Karen could potentially, worst case scenario, Karen could be in jail. Worst case scenario, this could be Karen's last night of freedom. Think about that. Think about that. 4.5 days. That sounds about right. I think they went into that 5th day and then she declared the mistrial. Yeah, really upset about Delphi. I still am. I still can't quite believe that happened, given how bad the state's case was. Yeah, haunt you forever. I know. It isn't an exaggeration. It really isn't. It's marred my faith. Really, seriously, marred my faith in criminal justice and the effectiveness of jury trials. Delphi all over again. Please don't say that. But it's potentially true. This worst case scenario could really be Karen's last night of freedom. If the jury have, they've just gone, oh, well, we don't know, she must be guilty. If they've just gone, it's too confusing, don't know, she must be guilty, they'll come back with a verdict tomorrow and Karen will be in jail. That's it. That's all. Now, look, if that happens, they have got excellent grounds for appeal. They have got so many grounds for appeal. But that doesn't, she'd be in exactly the same position as Richard Allen is in right now, that it takes so long. Like, the appeals process is lengthy. So she's going to be sitting in some state prison somewhere, I assume, for what, a year, 2 years? It's really horrible to think about. When you know in your bones, I know in my bones that Karen Read is not guilty. I have not seen one shred of evidence that I can use to say, okay, well, what about that? There's nothing. There's seriously nothing. And John O'Keefe's body tells the story. Everything else is secondary. John O'Keefe's body tells that story. All right, I'm going to end the poll. All right, interesting. Interesting. So 38% thinks it's going to be 2 days. 34% less than a day. 20% less than 3 hours. And then 6% hung. Interesting. I thought there'd be more who think it's hung. Interesting. I think potentially 2 days. I'm always wrong. I can never gauge how long a jury's going to take. I'm always wrong. So if I say 2 days, then you know for sure it's not going to be 2 days. I always guess wrong. I just don't know. I genuinely, you can't predict juries. It's really hard, especially when you can't see them. If you can't see them, then you don't know what the facial expressions are like. You can get a gauge for how attentive they are. I know some of the reporters who were in court are giving commentary about what the jurors are doing. Obviously they have to, keep it quite limited, but we know that some of the jurors write a lot. They write copious notes. We know that there's one who barely takes any notes. Listen, when I was a juror, I barely took notes. So that really doesn't mean anything. It might mean that they've just got a really good memory and they want to concentrate on listening rather than writing. What they did for us, and I don't know whether this is something that they do in all UK courts, but they gave us like a file at the beginning of the trial. They gave us like a file with, there's a whole bunch of papers in it. So all the things that they were going to display on the screen, like maps, the autopsy diagrams, there was a bunch of stuff in there. And they gave us that right at the beginning of the trial. And then through the trial, when they were presenting evidence on the screen, they were directing us to a certain page in our file. And they were like already agreed exhibits. And then when there was new exhibits submitted, then they would give us, if it was, they could give us paper. Like obviously things like CCTV, they can't give you paper. They gave us and told us to put it in a certain place in our file. So it was really good. And I virtually didn't write anything because everything I needed as a prompt were in the file. I think the only thing I really wrote notes on was when the medical examiner talked about the autopsy. I wrote some extra stuff on the autopsy diagram just to remind myself. But for me, that case hinged on the CCTV. That was what I went straight to. In the deliberation room, they gave us a laptop that was, air gap. There was no way you could get on the internet. There was nothing on it. It was completely blank, apart from the CCTV imagery, of which there was a lot. And that's what I did. I went through the entire CCTV. That was what I needed to see, and I went straight to it. So I directed the CCTV discussion and whatever. So yeah, I don't know whether that's something that all UK courts do or just something that judge does, but I thought it was really good that we got this file up front, and it didn't mean anything to us on day one, but it just made it so much easier that, you know, things like maps and diagrams and stuff like that, so much easier when you've actually got a paper copy. So yeah, anyway, all right, I've been on here a while, but we do have a while. They're only starting at 10 o'clock today, so we've got like an hour and a quarter before they come. Don't take notes. When I was at university, when I did my degree, my first degree, my psych degree, I got so good at note taking, I could literally take down word for word pretty much what the tutor was saying, what the lecturer was saying. I got so good, I got so fast. I could hardly read my own writing, but I used to take copious notes in lectures. But when it mattered, let's say, when it mattered, when two people's freedom was at stake, I just wanted to listen, and I wanted to look. I wanted to have absolutely full attention on the witness. Like everything, all of my focus was on the witness. And because I knew I had the file, then that kind of allowed me to have that ability to really concentrate on the witness rather than thinking, should I take notes, or is this that important that I need to write that down? You know, because you can either write everything down or write nothing down, because you don't know what's important. And especially at the beginning, you don't know what's important. Everything's important. So I chose not to take notes. But like some of my fellow jurors, they were scribbling and writing. Oh, God knows, I have no idea what they were doing. But then the file, when it was over, like each day, like they gave us an extra notepad as well, but they left everything like exactly as it was. Like they told us to leave everything. And I did a test. I thought, do they really not look? Do they really, like, does the cleaner not come in and, you know, move stuff to clean, you know, to dust? So one day I pulled a couple of hairs out of my head and I placed them strategically, like between pages of the file. And I think I had one that was like positioned around the notebook, and my hairs had not moved. Like genuinely, they did not move anything. Like it was every day that we left. When we came back the following morning, everything was exactly the same as we'd left it. So yeah, anyway, that's my experience. All right, guys, thank you for joining me. I don't know whether I'm going to do a recap of today, because if it's just a charging conference and a few arguments, I don't really want to subject anybody to a relatively boring. It's a necessary part of the trial, obviously, but it's kind of dry. So unless there's any like fireworks that I want to talk about, then there's not going to be a live stream tomorrow recapping the charging conference. Unless there's fireworks, and then I think I will. Just so I can laugh at Hank Brennan just for one more time. All right, so thanks for joining me. Thanks as always to the mods. It's gone very dark in here. It looks like rain. My washing's out, so I'm going to go and get my washing in, because I'm sure it's going to be dry, because it's been so windy. It's been a beautiful drying day here in Northern England. All right. There's a Summer Wells video out on Michelle After Dark. If you're following the Summer Wells case, there has been some important updates in that case. So go and check out that video if you're following the Summer Wells case, and I will see you very soon. Bye, guys.